The accuracy-related penalty is equal to 20% of the understatement of tax. For example, if the IRS determines that an additional $100,000 of income tax is owed, the IRS may assess a $20,000 accuracy-related penalty. This penalty only applies if the understatement is due to negligence or the understatement is substantial. The penalty should not be imposed or removed if the taxpayer had reasonable cause for the understatement. There are a number of circumstances that establish reasonable cause for not imposing an accuracy-related penalty. The leading case on reasonable cause for avoiding penalties is United States v. Boyle. The Neonatology Associates v. Commissioner case says that reliance on a tax advisor can qualify as reasonable cause. It even says that the taxpayer need not get a second opinion. The advisor has to be a competent professional to justify reliance. The taxpayer also has to have provided the necessary and accurate information to the advisor, and actually relied in good faith on the advisor's judgment. The court has even extended these cases to reliance on bookkeepers whose work is incorporated into tax returns. There are other court cases that limit the application of this law. For example, one cannot rely on an advisor who makes obvious errors. One cannot rely on an advisor if they did not even review the returns. One has to be able to show that the advice was actually provided. A mistake of law is another circumstance that has been found to be reasonable cause. The Higbee v. Commissioner case is the leading case for this proposition. It stands for the idea that an honest misunderstanding of the law that is reasonable in light of the facts and circumstances can qualify as reasonable cause. For an honest misunderstanding, it may help if the tax issue involves complex tax positions or tax reporting. As an example, Elaine v. Commissioner involved the reporting of IRA distributions. The court noted that taxpayers often fail to realize that there is no hardship rule that exempts these distributions from tax. The IRS often does not agree that the taxpayer has established reasonable cause. These issues are often contested in IRS appeals and in court.